Good morning. Happy Monday. For those of you who aren't aware, the old number that you would be able to look up Chauncey Hollingberry's federal criminal case has changed. It doesn't work. It won't give you all the new stuff. It was a magistrate number. The new number is for the case now that the magistrate is done with it. It'll have all the old stuff too. I just didn't want to spend the money for extra. So you'll notice a couple things. You'll notice that Chauncey's motion for change of counsel was granted, and his motion to compel is denied without prejudice. I looked to see if there's any real good reason for the denial of the motion to compel, and there wasn't. It just says defendant is directed to discuss this issue with new counsel to determine if a renewed motion is needed. The new counsel did not file a motion to compel, so there you go. And then the notices of intent, the court construed them as pretrial disclosures and directs defendant to discuss these issues with his new attorney. So not a whole lot happened there. The next day, the court appointed Philip Seplow as counsel. Philip Seplow, at least according to the Arizona bar, he has been admitted to practice before the United States Supreme Court. I did look to see if I could find any cases where he was the attorney of record on a U.S. Supreme Court case. Nothing came up after about 5 minutes of Googling, so I left it alone. It did say that he was active in California, so I checked that out, and he is not currently active in California, but he was at one point in time. So, but he's been practicing since '76, and what does that mean? I have refined my belief about experience. And to be perfectly honest with you, I think attorneys with 10 to 20 years of experience are the ones that are kind of hitting their prime. That they, if they're practicing in a field and they're doing the same thing over and over and over again, then 10 to 20 years, it just seems like if they get much past 20 years of experience, they just don't seem to be as invested, as driven anymore. They don't seem, generally speaking, hashtag this is my experience, so your mileage may vary. They don't seem to stay as up to date on changes in the laws and things like that. They rely more on memory than on research because, they've seen it all, right? So I remember doing vaguely this, but that doesn't mean it's the right thing to do. So you see some weird things from attorneys who've been practicing too long. So just FYI. But he's probably competent. I mean, he'll probably steer Chauncey at least in the right general direction, and he probably won't put up with a lot of Chauncey's bullshit. Having said that, we get down here to March 11th, where there's a notice of prosecutor misconduct by Chauncey Hollingberry. For fuck's sake. You might notice that the deadline for filing pretrial motions was 3/8 of 2021. And so this was filed late. Even if you are generous and you say, well, when was it mailed? It was mailed on March 9th. So it's late filed, and it's not even a motion. So in trying to figure out what the hell he's doing here, there are some things that you do provide, that the defendant would provide notice, defenses, I should say, that the defendant would provide notice to the prosecutor in a federal case. That you provide the prosecutor notice that you have an alibi. And you'd have to be specific about who you were with at what times, blah, blah, blah. Like I couldn't have been at Billy the Shark's house at 10 p.m. on the 15th because I was at Wanda the Fish's house at 10 p.m. on the 15th. And she's my alibi, and she can attest to me being there. The 10 o'clock news was playing, etc. Right? So that's one thing. Or another one that you'll commonly see is the insanity defense. If you say, look, I wasn't mentally competent, blah, 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 then you have to give the prosecutor notice of that. So there are some defenses where you have to give the prosecutor notice, but notice of prosecutor misconduct doesn't seem to be one of them, at least not that I can see. I don't know what he's intending to do with that. Maybe it's some artifact of Arizona law. Maybe it's something more arcane that I'm just not aware of. I'm not going to spend a bunch of time trying to Google a notice of prosecutor misconduct, especially when I could already tell it's not going to succeed. And here's your first indicator it's not going to succeed. If you get a new attorney on January 15th, and 2 months later you are filing pro se, I'm going to assume that you've discussed these various things with your attorney, and I'm going to assume he said, no, this isn't going to help. So I'm guessing that's what happened. Anyway, we'll go over his notice, and we'll see what we got. So it's the U.S. versus Chauncey Hollingberry. He still has the magistrate case number on it, so that's kind of weird because, like I said, it does have a new case number. It's no longer 20MJ03058. It's now 20CR00673, and this is the magistrate number. So, but minor things. You notice how they had to put the new updated one there. Again, they got the stamp on there that says that it doesn't comply with the federal and or local rules of civil procedure and tyranny of the clerk. All right. Now comes Chauncey Hollingberry, defendant, for a notice of prosecutor misconduct. It is the intent of the defendant to allege prosecutorial misconduct against the prosecutor, Lisa E. Jennis. One, or I. See, he always does the I, the beginning thing. Normally, like you'd have one would be the background facts, and then two would be like the argument where you'd present the case law and you would apply those facts to it. And then like three would be the conclusion or something along those lines. But he always only has one section, so I don't even know why he bothers putting that section number in there. Because as you can see, there is no section 2. It is just section 1 background facts. So all he gives us is background facts. So you're doing something wrong when all you give is background facts. Or actually technically when you mix in argument and opinion with background facts, but you call it background facts. So Lisa Jennis, prosecutor, has withheld exculpatory information from the defendant and the court in an effort to deny the defendant his due process rights, including but not limited to pretrial release, discovery. I guess. So the prosecutor does have a responsibility to turn over exculpatory facts. That was Brady versus Maryland, and was that other one Bagley, something along those lines. I forget the name of it. Anyway, you could make a Brady motion to the prosecutor to have him turn over exculpatory facts, etc. Usually they're pretty good about it. So I don't know what exculpatory facts that Chauncey hasn't been given. But then he goes on to say, and I don't know if this is related. I don't know if this is an exculpatory fact that was withheld from Chauncey because he does seem to know about it, or if it's an exculpatory fact that he thinks was withheld from the court, because from defendant and the court. So I don't know exactly where he's going. I don't think he knows exactly where he's going. I think he's just got verbal diarrhea, or I guess it's written diarrhea, not verbal. Anyway, In the initial hearing to determine detention, the prosecutor alleged, and I'm going to stop there. So, at the initial hearing to determine detention, for pretrial detention, the prosecutor can proceed on what's called an offer of proof. Offer of proof is basically saying, look, if called upon to produce witnesses and to produce documents and things like that, I would produce witnesses who would truthfully testify to X. And I would produce documents that would show Y. So it's called an offer of proof. It's basically don't waste the court's time by trying to do this stuff. It would take a lot more. Basically, you'd have to try the case at the pretrial detention, and the court doesn't want to do that. Basically, they're saying to the prosecutor, look, tell us what you would prove if you had to prove it. And then the defense, okay, do you have any rebuttal? What is your rebuttal to what the prosecutor says they could prove? So that's really what we're looking at. I know he's calling it alleging, but it's an offer of proof, and it's a little bit different, I guess. It's at the end of the day, it's going to be the trier of fact who's going to determine whether or not the witnesses and evidence is true or not. So I guess alleged works, but it's an offer of proof. It's the right level of proof to offer at a detention hearing. The prosecutor alleged the defendant was a threat to the community because he was ready to use an AR-15 assault rifle and level 5 body armor. Okay, so he's a threat to the community because he's ready to use an AR-15 assault rifle and level 5 body armor. Okay, so the prosecutor says he is ready to use a rifle and body armor. So what Chauncey's going to show us is that Chauncey was not ready to use a rifle and body armor. I find the term assault rifle distasteful because AR-15s are sporting rifles, not assault rifles, sporting rifles. AR does not stand for assault rifle. It is not an assault rifle. It is a sporting rifle. It fires rounds that the circumference of the rounds are barely bigger than a .22. I mean, it's not the deadliest rifle known to man. They make much larger bullets with a lot more powder behind them. So it's not an assault rifle. Anyway, I digress. He's going to show that he was not ready to use a rifle or body armor. She then played for the court videos titled Arizona Attorney General Declares War. At the conclusion of these videos, so apparently there's more than one video with the same title. At the conclusion of these videos, the defendant mentions he is going to the gun range with level 5 body armor. So at the end of this video that she just played, he says, I'm going to the gun range with level 5 armor, level 5 body armor. So it sounds like he's ready to use a rifle and level 5 body armor, doesn't it? Because he just says, the defendant says he's going to the gun range. That's why it's always so crucial. That's why attorneys tell people all the time, shut your damn mouths. Anything you say can and will be used against you. Had Chauncey never said that he was going to the gun range with level 5 body armor, he might not have been in prison waiting for trial or in jail waiting for trial. He might have been free while he's waiting for trial. You never know. It is the government's conclusion. The cryptic comment was directed at the Arizona Attorney General, Mark Brnovich, I guess. Okay. But remember what the prosecutor was saying was that Chauncey was a threat to the community because he was ready to use an assault rifle and armor. And now he's talking about who he's going to use it on, right? Okay. Exculpatory evidence was withheld from the court and the defendant in the form of videos, which I'm sure are going to say that Chauncey was just kidding. Ha ha, I would never use my assault rifle and body armor by going to the range, and I certainly wouldn't use them at the Arizona Attorney General, Mark Brnovich. And for those of you out there who think that you're being coy with all these subtle threats are never going to save you. Just because you make your threat subtle, I mean, if people can perceive it as a threat, it's not. If they can't perceive it as a threat, then you're not threatening anybody, and that's great. But if people can perceive it as a threat, it doesn't matter how subtle you make it. All right, so the exculpatory evidence was withheld from the court and the defendant in the forms of videos titled Synagogue, and I think this means Jews, but maybe it's Synagogue Jays, I don't know. Synagogue Jays make threats. In these videos, the defendant discusses the violent threats he received from Aaron McKinney, who visited the defendant's home with a gun. The defendant obtained an injunction against harassment against Aaron McKinney due to his stalking behavior. The above videos are the origination of the cryptic remark regarding body armor and a gun range, and were intended at Aaron and not at the Attorney General. Now, so he's saying, look, these comments I made about the gun range and the body armor, they were directed at Aaron McKinney, which means that the defendant was a threat to the community because he was ready to use an AR-15 assault rifle and level 5 body armor. You literally undercut any argument you could have made in your own handwriting, and you signed your name to this. In fact, the YouTube video poll asking whether the defendant should visit a sidewalk in front of a synagogue with an AR-15 assault rifle and 2 cameras was aimed at Aaron McKinney. So he's saying he put up a poll. The poll that I put up threatening to visit a synagogue with an AR-15 assault rifle, and again, it's a sporting rifle. I'm just calling it what he's calling it here. It's definitely a sporting rifle and not an assault rifle. But now he's gonna go to synagogues, and he's aiming it at Aaron McKinney. He says Aaron McKinney is an Israeli Defense Force soldier. The defendant was with information that the individual was going to kill him. The defendant was attempting to convince Aaron he had a gun to defend himself. Which goes back up to he was ready to use an AR-15 sporting rifle and level 5 body armor. Bum, ba-da-bum. Congratulations, you played yourself. During the detention hearing, the prosecutor alleges, again, it's offer of proof, the defendant harassed his uncle by speaking about him on the defendant's media channel, the law offices of Daddy and Master. She alleged defamation of the uncle and trespass upon his property. Ms. Jennis neglected to mention that the defendant was accusing his uncle of embezzling $3,000 from his mother's trust fund and of subjecting him to various forms of criminal child abuse. So here's the way defamation works. Defamation is when you make a statement about somebody, like they embezzled $300,000 or like they committed criminal child abuse, and then a defense to defamation is that it's true, right? So this gal is saying, you, Chauncey, are out there defaming this guy. Now, your best bet would be to show it's true, but you simply being in prison and writing down the defamation over and over and over again, saying it's true, doesn't actually make the defamation true. If you could pull out a court record. If you could say, look, he was convicted of criminal child abuse, here's the court record. It was in this case, in this court, this date. Or embezzlement. He was convicted of embezzlement. This is the court case. This is the court. Superior Court of Arizona, blah, blah, blah. But you don't have that. You just have allegations. And so in order for you to prevail and say, I wasn't defaming him, you would actually have to prove, not continue to allege, but prove that he was embezzling and that he committed criminal child abuse. She also failed to mention that he was outside of a business, Hope Refuge, to document his uncle's embezzlement. So he was trespassing, apparently, on Hope Refuge's property to, in quotes, document his uncle's embezzlement. Now, embezzlement, just in case those of you who aren't aware of it, is where you take money from your employer. You're entrusted to take the money, like your boss gives you $500 to go and buy something for the business. And instead you take that money and you go to the slot machines. You've embezzled the money. It's like stealing, except you were kind of authorized to have access to the money in the first place, but you're supposed to use it for the purposes of the business. So how he would be able to, in quotes, document embezzlement from outside of Hope Refuge is beyond me. And I'm sure that the court is also going to look at it and be like, that's retarded. You are literally retarded for making that claim and expecting a grown-ass adult to believe it. Exculpatory information include filings in the civil defamation case, which, as mentioned above, were withheld from the court and the defendant. Filings in the civil defamation case don't necessarily make them true. There has never been, to the best of my knowledge, a trial in the civil defamation case. I don't think it ever got to that point where a judge was able to look at the evidence and determine whether or not there was or was not defamation. So I could be wrong about that, but I don't believe that it ever made it to trial. So that's why he's saying filings, and filings are worthless. You don't file the evidence in the case. You present it at trial, and then at trial, the judge or the jury will look at the evidence and will determine whether or not it is true or not. Lisa Jenness has been in regular contact to this day with Charles Cook's attorney, Raymond Chandler. And what does this have to do with whether or not she's withheld information? And prove it. Absolutely prove it. How do you think Chauncey Hollingberry, who is currently confined in prison or some sort of detention center, he's currently confined, how would he know who Lisa Jenness is having regular contact with? And I mean, just imagine anybody. Just imagine anybody that you know casually. Is an acquaintance from work still having regular contact with, I don't know. You just don't know. You don't know who's having contact with who. And it's not like Chauncey could be like walking down the street one day and see the two of them at a coffee shop together, because the dude's in jail or some other detention facility. I don't know if it's a prison or a jail, to be perfectly honest with you. I know the marshals have cell blocks in some sort of a detention center. I don't know if it is a prison or a jail. I don't remember. I don't really care. So I may use the two terms interchangeably in here. I understand that he's not been sentenced to prison time. It's some sort of a detention facility. It's in a jail or a prison. Charles Cook is the defendant's uncle mentioned above. Ms. Jenness is aware of Charles's embezzlement of trust funds from Lisa Cook's trust fund. And again, Where's your proof? Where's your proof? I think Lisa Cook is Chauncey's mom. Lisa has been working with Raymond Chandler in an effort to quash potential prosecution of Charles Cook. And again, just making an allegation doesn't change anything. The prosecutor wants Charles clean, in quotes, to enable him to testify against the defendant. I don't know that you need really to keep Charles very clean to have him testify against Chauncey. But I do know that prosecutors aren't going to just start digging into random people because sleazebags like Chauncey start saying this guy's an embezzler, this guy's a criminal, child abuser, or what have you. The defendant, upon information and belief, so normally you use information and belief if you believe something to be true, or if you have information that something is true, but you don't know it to be true. And normally you would use it in like a complaint, where you would say something along like a criminal or a civil complaint, where you'd say, on information and belief, person X did Y, so that you've alleged that they've done it so that you could do discovery on it and learn it to be true. It doesn't help him here because essentially this is, I guess, a declaration, but it's what he can prove that really would matter. And let's look at this, I guess. Upon information and belief knows, which would make it not information and belief. Either you know it or it's on information and belief. Lisa Janice drinks cocktails with other attorneys. Well, holy shit. I drink cocktails with other attorneys. Oh my God. Anyway, that doesn't mean anything. So, okay. She has been infringing on the defendant's ability to representation by intimidating other attorneys in regards to this case. I don't understand that. Chauncey's now had 3 attorneys, I believe. I believe this is his third or fourth. No, it's his fourth. There were 2 DOJ guys, Department of Justice, public defenders. There was one of the basically contracted defenders, and now he's got a second contracted defender. So I think there's been 4. Chauncey's had 4 attorneys. He's currently represented and 4 attorneys. So he's had representation. And this whole thing about attorneys being intimidated by other attorneys. I have never seen an attorney intimidated by another attorney. You don't see it. It doesn't happen. I've never been intimidated by another attorney. I mean, you get up there and you say what you got to say, and you win or you lose. I mean, you give it your best, but at the end of the day, you're just doing your job. And I don't think that Lisa gives 2 shits about Chauncey other than the fact that it's her job to put pieces of shit in jail. And Chauncey certainly looks like a piece of shit. I'm not saying he deserves to go to jail. I'm not saying he's guilty, but I am saying he does appear to be a piece of shit. Okay, Central Avenue and downtown Phoenix are Lisa's favorite after-hours social destinations with other attorneys. Again, and this is standard practice with many attorneys to draft deals under the table to screw their clients over in court. That is patently false. No, I've never seen that. But okay, certainly you would want to have something. You'd want to have something to show this. Lisa is allegedly a raging alcoholic and participating in these backroom deals. So this is obviously just him trying to, I guess, prejudice the court against Lisa, and it's certainly not going to work. And he submitted this the 7th day of March 2021, so maybe the court will give it to him, even though it was mailed out on the 9th. Maybe it takes 2 days for it to go from Chauncey's cell to the post office. So, and then he did, thankfully, I mean, that's kind of nice of him. He did serve his own attorney and opposing counsel, the prosecutor. So that's pretty good. So anyway, that's the latest line of garbage coming out of Chauncey. Thanks for watching. Have a great day.